In this video, we share 3 must-have tips that you should know when you're first charged in court. First, you should keep in mind this overview of mentions court events. When you arrive at the state courts, you may approach the information counter for assistance if you need help locating the mentions court. There are 4 day mentions courts, 4A, 4B located at level 4 and 7A and 7B located at level 7. There are 2 night mentions courts, 4AN and 4BN. Once at the mentions court, you will register your attendance at the registration kiosk located outside the court. When this has been done, you can sit down at the gallery and wait for your turn for your case to be called or mentioned. When the court is in session, please do not use your mobile device as it may disrupt court proceedings. If you have a lawyer, please wait for your lawyer to be present before proceeding into the courtroom. This is because your case will only be called once your lawyer is present and has registered his or her attendance with the court. Your charge or charges will be read and explained to you by an interpreter before your case is mentioned. A charge is an official document prepared by the prosecution that would include information on the date, time, place, and nature of the offense alleged to have been committed. When your case is mentioned, you should come forward into the dock if you are on bail or to the designated area if you are not on bail. You may be asked for your intended plea, namely, guilty, not guilty, or no indication. An interpreter will be present to assist you in the language which you choose to speak in. If you admit to the charge or charges, you are pleading guilty. If you do not have a lawyer yet, you will also be asked if you would like to engage a lawyer or apply for legal aid from the Public Defender's Office. You should inform the court if you wish to engage a lawyer or apply for legal aid, as your case will have to be adjourned for you to do so. Otherwise, a PG hearing date will be fixed, and this will normally be in another court. If you do not admit that you are guilty of the charge or charges, you are likely claiming trial. Further dates may be fixed for parties to prepare for trial. You may choose to either defend yourself or appoint a lawyer to defend you at the trial. If the case is adjourned to another date and you're currently on bail, the court will decide if you can continue to be released on bail until the next hearing. The court may also revise the bail amount and the bail conditions. If bail is offered, your bailer may go to the bail center at level 4 to post bail for you. You will be allowed to make phone calls to find a suitable and willing bailer. Your bailer should bring along your passport if it has not already been surrendered to the police. Once the bail is processed, you will be released. If bail is not offered, or if bail is offered but you do not have a suitable bailer, you cannot be released. A mentions slip indicating the next court date will be issued to you. This is an important document. Do not lose it. If you fail to attend the mentions court, a warrant to arrest may be issued against you. If you are on bail, your bailer will be asked to show cause, which is to explain to the court why the bail amount should not be forfeited, and they may lose all or part of the money or property pledged as security. Second, you should know the key individuals involved in the mentions court. The judge is the officer presiding over the mentions court. You should address the judge as Your Honor. The judge is supported by a court officer who assists the judge in the proceedings. The interpreter is a person who explains the charges to the accused person in a language he or she understands. The prosecutor is a person who brings the charges against the accused person. The accused person is a person who is facing charges before the court. a lawyer is a person who represents the accused person in court. Third, you should know these bail essentials if you are offered bail. Bail is property pledged or deposited by someone as security that the accused person will return to the court on a specified date and time until the conclusion of the case against the accused person. If the accused person does not return to court or fails to comply with any of the bail conditions, the bail amount may be forfeited. A bailer, also known as a surety, is a person who agrees to provide security for the bail amount ordered by the court so that the accused person may be released from remand. This means they need to guarantee that the full bail sum will be paid to the court if the accused person fails to appear for their court events or breach any bail conditions. For some cases with higher bail amounts, the court may allow more than one bailer. A surety must be a Singapore citizen or permanent resident, unless the court specifies otherwise, above the age of 21. He or she must not be A. a bankrupt, B. a co-accused in the same proceedings as the accused person, C. the subject of any other pending or ongoing criminal charges in the state courts and the Supreme Court, and D. a victim stated in the charges. The surety must be physically and mentally fit to carry out the duties of a surety. He or she must be prepared to bear the consequences of any breach, that is, lose the amount he or she stood bail for until the case is concluded. It is an offence for any person to agree to indemnify a surety for any liability incurred as a surety to a bail bond. Duties of a surety are: A. To ensure the accused person attends all court dates punctually. The surety should find out court dates in advance and make sure the accused person is present. B. The surety must ensure the accused person follows all bail conditions, including not leaving Singapore without court permission. C. The surety must maintain daily contact with the accused person and monitor their movements to ensure compliance. If the surety loses contact with the accused, the surety must lodge a police report within 24 hours. And D. If the accused person falls ill on a court date, the surety should ensure they see a doctor immediately for a medical certificate stating they are unfit to attend court, then inform the court on their behalf. Do note that not all cases are granted bail, and there may be additional bail conditions imposed by the court. The court may order that bail be monetary or non-monetary. If non-monetary bail is ordered, there is no need to pay actual cash or money to furnish the bail. However, the surety needs to make a declaration on the pledge of assets. Documents to be prepared by the surety include the accused person's valid passport, the surety's NRIC, printed bank account number endorsed by the bank. The operating and filing hours of the bail centre located at level 4 of the State Courts building are as follows: